in whole or in part other than those requested. In the present case, having considered the terms of the provisional measures requested by South Africa and the circumstances of the case, the Court found that the measures to be indicated need not be identical to those requested. The Court considered that, in conformity with its obligations under the Genocide Convention, Israel must immediately halt its military offensive and any other action in the Rafah governorate which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part. The Court recalls that in its order of January 26, 2024, it ordered Israel inter alia to, I quote, take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention, end of quote. In the present circumstances, the Court is also of the view that, in order to preserve evidence related to allegations of acts falling within the scope of Article 2 and Article 3 of the Genocide Convention, Israel must take effective measures to ensure the unimpeded access to the Gaza Strip of any commission of inquiry, fact-finding mission, or other investigative body mandated by competent organs of the United Nations to investigate allegations of genocide. The Court also considers that the catastrophic situation in Gaza confirmed the need for the immediate and effective implementation of the measures indicated in its orders of January 26, 2024 and March 28, 2024, which are applicable throughout the Gaza Strip, including in Rafah. In these circumstances, the Court finds it necessary to reaffirm the measures indicated in those orders. In so doing, the Court wishes to emphasize that the measure indicated in paragraph 51(2)(a) of its order of March 28, 2024, requiring, I quote, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance, end of quote, necessitates that the respondent maintain open land crossing points, and in particular the Rafah crossing. In view of the specific provisional measures it has decided to indicate, the Court considered that Israel must submit a report to the Court on all measures taken to give effect to this order within 1 month from the date of this order. The report so provided will then be communicated to South Africa, which shall be given the opportunity to submit to the Court its comments thereon. The Court recalls that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The Court underlined that the present order is without prejudice to any findings concerning the respondent's compliance with the orders of January 26, 2024 and March 28, 2024. In its orders of January 26, 2024 and March 28, 2024, the Court expressed its grave concern over the fate of the hostages abducted during the attacks in Israel on October 7, 2023, and held since then by Hamas and other armed groups, and called for their immediate and unconditional release. The Court finds it deeply troubling that many of these hostages remain in captivity and reiterates its call for their immediate and unconditional release. I shall now read out the operative part of the order. For these reasons, the Court, by 13 votes to 2, reaffirms the provisional measures indicated in its orders of 26 January 2024 and March 28, 2024, which should be immediately and effectively implemented. In favor, President Salam, Judges Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi. Against, Vice President Sebutinde, Judge ad hoc Barak. 2. Indicates the following provisional measures. The State of Israel shall, in conformity with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, and in view of the worsening conditions of life faced by civilians in the Rafah Governorate, A, by 13 votes to 2, immediately halt its military offensive and any other action in the Rafah Governorate which may inflict on the Palestinian group in Gaza conditions of life that would bring about its physical destruction in whole or in part. In favor, President Salam, Judges Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi. Against, Vice President Sebutinde, Judge ad hoc Barak. By 13 votes to 2, maintain open the Rafah crossing for unhindered provision at scale of urgently needed basic services and humanitarian assistance. In favor, President Salam, Judges Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi. Against, Vice President Sebutinde, Judge ad hoc Barak. C, by 13 votes to 2, take effective measures to ensure the unimpeded access to the Gaza Strip of any commission of inquiry, fact-finding mission, or other investigative body mandated by competent organs of the United Nations to investigate allegations of genocide. In favor, President Salam, Judges Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi. Against, Vice President Sebutinde, Judge ad hoc Barak. 3. By 13 votes to 2, decides that the State of Israel shall submit a report to the Court on all measures taken to give effect to this order within 1 month as from the date of this order. In favor, President Salam, Judges Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi. Against, Vice President Sebutinde, Judge ad hoc Barak. I shall now call on the Registrar to read the operative part of the order in French.
Par ces motifs,